Great to see so many of you here today, and welcome everyone to this IES webinar, Life After Finch, Implications of the Supreme Court Judgment for Environmental Impact Assessment. This webinar has been organised jointly by the IES's Environmental Impact Assessment Community and their Environmental Policy Implementation Community, or EPIC. EPIC is the newest IES community which brings together members from across the environmental sciences to share their experiences and call for ambitious and deliverable policy, as well as providing members with the knowledge, insights and tools to help them deliver this on the ground. EPIC recently launched free membership to local authority environmental professionals, and shortly I'll post a link to the chat with more information on both of the communities and how you can get involved. This webinar today will be presented by Kate Tandy, Head of Litigation and Casework at the Office for Environmental Protection, or OEP. Kate leads on the legal aspect of delivering the OEP's enforcement function. Kate has worked across a wide range of environmental law issues, having previously worked as Chief Legal Advisor for the National Farmers Union, where she was involved in a number of high-profile judicial review cases affecting the agricultural industry. Kate was also listed on the ENDS Report Power List 2024, the UK's 100 most influential environmental professionals, as an unsung hero. As always, there will be a chance for questions at the end of Kate's presentation, so please do submit these in the Q&A option, which you can find at the bottom of your screen, and you can do this at any point during the presentation, and I'll ask these on your behalf later on. A massive thank you to you, Kate, for joining us. I'll hand over to you now.
Great, thanks, Ethne. Thanks everyone for joining today. I hope I will be able to give you a kind of informative view of the case of Finch, bit of insight into the OEP's involvement, and a little look ahead at what the implications are of the judgment for future EIA. I should say at the outset, I'm not a practitioner. I have never undertaken an environmental impact assessment myself or attempted to write an environmental statement. So I can't offer any kind of great practical insight, and I'm sure those of you watching will have a much better idea of the kind of practical opportunities and challenges offered by this judgment and the development of the law in this area. But I will try to talk a bit about some of the legal implications and also some of the things that have happened since the judgment was handed down in June, and a little look at what that might mean for the future. So I'll just move my slides on, and I hope you can all see that now. This is what I intend to cover over the next half an hour or so, and I'll try and leave plenty of time for questions at the end. So I'll just start with a brief introduction of the OEP. We'll look at the background to the case, the nature and purpose of our intervention in it, what the outcome of the Supreme Court was, kind of look at some of their reasoning and how they reached the decision, and then finally probably the bit of significant interest. So I'll try and spend a decent amount of time on that, looking at the impact on other developments and what has happened since the judgment was handed down. So moving swiftly on then into a very brief introduction. I'm sure many of you will have heard of the Office for Environmental Protection, but I just thought it was worth running through at a high level what it is we do and who we are. So we are I think it's still safe to say, relatively new public body. We came into being in November 2021 under the Environment Act 2021, and we have four main functions. The kind of principal objective is to protect and improve the environment, and we do that by holding government and other public authorities to account. So the way in which we do that is made up of four key functions. The first one there that you can see on the slide is we can provide advice to ministers regarding proposed changes to environmental law. We can do that wherever a proposed change to environmental law is made. And we can also, so we can do that of our own volition, and then ministers can also ask us directly to provide advice on any matter relating to the natural environment. So we have done that on a couple of occasions in relation to previous government's Nature Green Paper, and then we've also provided advice in relation to the environmental targets that were set under the Act. Secondly, we scrutinise environmental law, so we have a function to monitor and report on matters concerned with the implementation of environmental law, and we've published several reports under that function already. One of our most recent ones being in relation to the Water Framework Directive regulations and the implementation of those and kind of how it works on the ground. Then we have our ongoing scrutiny of government's progress towards meeting its targets, its long-term targets and actions in the Environmental Improvement Plan. So this is in relation to both England and Northern Ireland. That's where our functions are. And so we monitor and report on that progress, and we do that annually. Our next report is due out in January 2025. And then finally, we have an enforcement function where we can receive complaints and we can also receive information, look at information that we've gathered from other ways. We can investigate suspected serious failures to comply with environmental law by public authorities. And ultimately, we can take those public authorities to court if we need to. And under that enforcement function, we have an express power to intervene in judicial reviews brought by third parties, which is what we did in the Finch case. So I hope that's just a very useful brief overview. Happy to take any questions on the OEP more broadly in the Q&A session, as well as talking about Finch. So moving on then to actually the case itself. I thought it'd be helpful to just set out a little bit of the background to the case and how it ended up in the Supreme Court. So the case related to planning permission that was granted for new oil well development, well, new and continuing oil well development by Horse Hill Developments in Surrey, and Surrey County Council granted planning permission on the 27th of September 2019, and they had undertaken a environmental impact assessment, or the developers had been taken into account, as you would expect, but that EIA did not assess the downstream greenhouse gas emissions that would result from the eventual combustion of the oil. So the oil will be obviously extracted, refined, and eventually burnt, and it was those downstream greenhouse gas emissions which Mrs. Finch, on behalf of the Wheeled Action Group, considered should have been taken into account as part of the EIA process. So Mrs. Finch issued judicial review proceedings, and that permission was actually initially refused on the papers, was then granted on a renewal application, and it was heard in the High Court in the first instance, and that decision was handed down in December 2020, and the High Court found that as a matter of law, those downstream emissions that come from the eventual burning of the oil could not be and were not an effect of the project for the purposes of the EIA legislation. So that was Mr. Justice Holgate's decision, and Mrs. Finch appealed that decision to the Court of Appeal. The Court of Appeal came to ultimately the same conclusion, in that they considered that Surrey County Council's grant of planning permission was lawful, but they did so for slightly different reasons. So the majority in the Court of Appeal found that those downstream greenhouse gas emissions could be considered an effect of the project and could be assessed as part of the EIA, but it was a matter of evaluative judgment for the relevant planning authority in the specific circumstances. So, and they found that in this case that Surrey County Council was entitled to not assess those effects, and there was a dissenting judgment at the Court of Appeal. Lord Justice Moylan considered that in this case, Surrey County Council should have taken the emissions into account. So that was how it ended up going to the Supreme Court. The Court of Appeal decision sort of left things a little bit uncertain in terms of sometimes it could be an effect of the project that should be taken into account, and maybe sometimes it wouldn't be, and that's up to the planning authority. So I think that was part of the reason why it was brought to the Supreme Court. So I think it's worth just setting out, or just move on to kind of our intervention, but just in terms of what was then in front of the Supreme Court for it to decide. everybody agreed, all of the parties to the case. So the parties to the case, just to run through, was Mrs. Finch had brought the case on behalf of the Wheel Action Group. Then there was Surrey County Council, obviously the one who'd made the decision. And then there were two interested parties, Horse Hill Developments Limited themselves, obviously they're the ones directly impacted, and they had the planning permission, and the Department for Levelling Up Housing and Communities, as it was then, to look at the bigger kind of planning policy issues. So all of the parties in the case at the Supreme Court agreed that the project required EIA. There was no dispute there, and it obviously had been undertaken. And they all agreed, and this is quite crucial when we come to look at the reasoning of the court, that it was inevitable that the oil that was extracted from that well would be refined and eventually combusted, and therefore would eventually produce those greenhouse gas emissions. So, and it was also agreed between all the parties that it was possible to estimate what those emissions would be, looking at the volume of oil that would be taken out and what the emissions would be at the end. So therefore, the only question for the Supreme Court to consider was whether those emissions are properly to be considered effects of the project. And we'll look in a minute that obviously that was looking at whether they were indirect effects of the project. So the OEP became aware of, we were aware of the Court of Appeal case, and then we became aware of the proposed appeal to the Supreme Court, and we had been undertaking some work. We had a report, we published a report late last year in relation to environmental assessments more broadly, and what was working well and what wasn't working so well. So we'd already been looking at this area of law, and we had a look at the decision in the Court of Appeal, and we considered that it was quite left the law in quite an uncertain position, and it was quite difficult for planning authorities to actually work out when they were and when they were not supposed to assess these kind of emissions. And we thought that it was a good opportunity for the Supreme Court to, for the first time, take a look at what is meant by indirect effects. How do you assess whether something is properly an effect of a project? And we encouraged the Supreme Court to set out kind of principled approach to that question that could then be followed in relation to other projects. And so our purpose for doing so was to seek clarity in the law. We didn't take sides between the parties on the facts, so we weren't concerned with what had actually happened in relation to the underlying planning decision that was made, but we were looking at the question of law as to whether it was or wasn't an indirect effect. And our kind of ultimate goal in doing so was to ensure proper decision making that enhances environmental protection. So obviously, I'm sure everybody on this webinar will know that the outcome, an environmental impact assessment does not dictate the outcome. It is a process that must be followed. And so our purpose was sort of more to seek to highlight the importance of transparency and ensuring that those impacts are assessed. And then if there is going to be harm to the environment, the planning authority still decides to go ahead with the permission, at least it's done in a transparent way. So that was kind of why we made our intervention. We've published our written submissions on our website. So if anybody is particularly interested in finding out more, they are still up there. So you can see what we said. And I'll come back a little bit more detail when I look at the decision itself. So it's quite interesting if you think about where we are at this point. The Supreme Court, a total of 11 judges looked at this case overall. And if we move on to the Supreme Court judgment, the Supreme Court it was a split decision. So it was a 3-2 majority decision. So overall, across the whole life of the case, 11 judges had a look at it. 7 considered that what Surrey County Council had done was lawful, and 4 considered that it was unlawful. 3 of those 4 were in the Supreme Court, so they're the ones that ultimately count. There was a majority judgment from Lord Leggett, Lord Kitchen and Lady Rose, and they found that the council's decision to grant planning permission to the oil well was unlawful because the environmental impact assessment failed to assess the effect on climate of the downstream greenhouse gas emissions. So they came to the conclusion that whether or not something is an effect of a project is a question of law. The place where there is space for judgment of the relevant planning authority is whether that effect is significant or likely. Here, as I mentioned earlier, there was no dispute that not only were these emissions likely, they were in fact inevitable. So I think that's an important thing to remember, because I do think that had quite a significant influence on the court's reasoning. So the part of the reason why the majority found that these emissions were in effect was that the strong causal connection between extracting the oil and those resulting emissions when it's refined and burnt. And they said they kind of considered 3 different tests for causation, you know, the kind of but for test, but for this would the emissions have been there, and then they also considered the kind of intervening effects and looked at those tests. But ultimately they said, well, all of these tests of causation are met here because it's a very strong causal connection. So they didn't quite go as far as saying the correct test for causation for assessing whether something is an indirect effect is this test. That perhaps would have been what we would have maybe hoped they would have done, but I think there's still quite a lot of useful guidance in there from the court. So just to talk a little bit more about some of the things that they specifically mentioned, one of the arguments that was being brought by Surrey County Council, and particularly strongly Horse Hill Developments and also the Secretary of State, was that the emissions were not an effect of the project because the oil would have to undergo an intervening process before it was burnt. So it wasn't that you would extract the oil and directly burn that oil. It would have to be refined, which would mean it would go to a different site, and that refinery itself would have undergone an environmental impact assessment. And the court found that the fact that it would go through another step before it's combusted, and the fact that the eventual emissions would be released in areas that were unknown to anybody doesn't mean that they're not an effect of the project. And what they said was that the approach that was taken by the council and the developer was that they only looked at the greenhouse gas emissions that were directly released from the well site, and that, according to the court, obviously excluded indirect emissions, and the EIA legislation requires you to assess both direct and indirect effects. So the court acknowledged that while the time and place of the emissions is unknown and outside of the developer's control, whether or not the emissions occur at all was considered to be within the developer's control. So that kind of line of argument was dealt with in that way. And they also made a point of talking about the principle that the EIA should take place at the earliest stage of a project, and here that was considered to be where the crude oil was extracted, and that should happen even if there would be further EIA later on in the process. So that's sort of broadly what the court decided, outcome being specifically in relation to fossil fuel extraction. It is necessary to assess those downstream emissions that will arise from the eventual burning of the fossil fuel. There was a strong dissenting judgment from Lord Sales and Lord Richards, and they agreed with the High Court's finding. So they agreed that as a matter of law, you could not include these emissions as an effect of the project. So it's quite interesting there that both the majority and minority of the Supreme Court agreed that the question of whether something is an effect is a matter of law, and they also both didn't think that the Court of Appeal's decision was right. So I think it was clear that the kind of uncertain position that the Court of Appeal had left was definitely not one that was attractive to the Supreme Court. But you know, it was a close thing, and the dissenting judgment is quite strong. If anyone's interested, they're interesting judgments to read. I think even for non-lawyers, I think that would be true. So I'll just talk briefly about the relevance of the OEP's intervention. I mean, this is perhaps a little bit kind of, you know, self-congratulatory, but I will say it anyway. There were 4 interveners in the case, and the OEP was sort of singled out as specifically having provided helpful submissions. And I suspect that was because we tried to go in at that kind of principle level, and a lot of what we had suggested can be seen through the court's reasoning. And we, for example, the fact that those greenhouse gas emissions were kind of subject to interim steps, or maybe would come out at a different, an unknown time and place globally, shouldn't mean that they're not an effect of the project that ought to be assessed. So I think that's kind of just briefly where we are with what the case itself found, and then I move on now to look at, well, what has been the impact, and I think that's probably the bit that's maybe of most interest. And this is a kind of, you know, the impact is not known fully. I think it's safe to say that the immediate impact is, as I mentioned a few minutes ago, for fossil fuel extraction projects, you must assess the downstream greenhouse gas emissions from the eventual burning. That seemed clear from the Finch case itself. In that case, Mrs. Finch's lawyers were very keen to kind of make clear that their argument was confined to fossil fuel extraction. That's what they were talking about, and they weren't seeking to expand the remit of environmental impact assessment more broadly than that. But clearly it does have some relevance. So looking at what we've seen since, some of you may be aware of the West Cumbria coal mine judgment. So in that case, that had been issued before the Finch case was heard in the Supreme Court. So it was paused until after the decision in Finch. And after the Finch decision, the Secretary of State in the West Cumbria coal mine case actually conceded and said that they would no longer defend the claim, because they conceded that these downstream emissions had not been assessed under the EIA, and they should have been. But West Cumbria Coal Mine Limited, perhaps understandably, continued to defend the case, sought to differentiate it and distinguish it from Finch. That case was decided on a number of grounds, and I won't go into the ones that don't relate directly to Finch, but the court found, the High Court, Mr. Justice Holgate, who was the original judge in Finch, he found that those downstream emissions from the coal mine should have been assessed as part of the EA following the reasoning in Finch. One of the arguments that West Cumbria coal mine was making was that the downstream emissions would not be significant, because that was intended to be a net zero coal mine, because the coal produced there would substitute coal that would otherwise have been mined elsewhere in the world, but overall wouldn't result in additional coal. Safe to say the High Court wasn't particularly impressed with that line of argument, and found quite strongly that the result of the Finch decision was that those impacts needed to be assessed. I think the other thing that is worth mentioning here that we can kind of draw out of it is as I said earlier, I think what is key to the reasoning in Finch is the inevitability of the effect. And so I think there's still a lot of room for likelihood and significance to be left to planning authorities' judgment. And so there may not be, and I don't know, those of you who do this day to day may be able to think of examples where there are, but there may be not that many other cases where it's so inevitable and it's so obviously significant that you would necessarily need to assess it following the line of Finch reasoning. But it does remain to be seen kind of where it will go in terms of how much more will need to be assessed. Has it extended the reach of environmental impact assessment? Has it set out that indirect effects go more broadly than we previously thought? I think that question still remains a little bit difficult to answer. I think we can answer it quite clearly in relation to fossil fuel extraction projects, but it's much more difficult to answer more broadly. And I think time will tell, and I'm sure there will be inevitably more litigation about it in the future. The next kind of bit of litigation to keep an eye out, again, it is relating to fossil fuel extraction, is there are similar judicial reviews to the West Cumbria coal mine case being brought in relation to the Rosebank and Jackdaw oil and gas fields. And again, the government has said that it won't defend those cases on the same basis that it conceded the West Cumbria coal mine case. But the developers, Shell and Equinor, are continuing to defend those cases, and they're due to be heard in Scottish courts in November, so in the next couple of weeks. So it'll be worth keeping an eye out for that judgment. But my current prediction would be that they will find that they should have assessed those downstream emissions following the line of reasoning in Finch. And then in terms of kind of what's happening outside of the strict legal sphere, there is new guidance on its way. The government actually published yesterday. So these slides, that link on my slide is slightly out of date. There is now guidance published for consultation about how you go about assessing downstream emissions. And so I think, again, that's an indication that certainly from government's perspective, they're looking to keep it narrowly looking at downstream emissions from new fossil fuel projects. That's what the guidance is looking at. And that consultation is open until the 8th of January 2025. So certainly probably any practitioners, anyone who's involved in actually undertaking those EIAs and compiling the environmental statements, strongly encourage you to have a look at that if you haven't already seen it, because that's obviously what will guide what happens in future. I've talked a little bit about assessing indirect effects in other projects. I expect that those of you on the call will have better operating crystal balls than I do on that, but it is quite interesting. The only other kind of final point that I wanted to flag, which remains, as far as I'm aware, a possibility, but we don't know if this new government is going to take it forward, is obviously a lot of you will be aware that the Levelling Up and Regeneration Act 2023 creates power to change the environmental impact assessment process and move to environmental outcomes reports. That was a policy of the previous government, but it may well be picked up by this government in its ambitions to increase growth and increase building of houses in particular. So it'd be interesting to see whether those environmental outcomes reports fundamentally change how you undertake an environmental impact assessment. But I think that's about as much as there is to say on that, but kind of watch this space is, I guess, my point on that. So I think pretty much on time, Ethne, ready to move to questions if anybody has them. I hope that was helpful.
Thank you so much, Kate. That was really interesting and useful overview of the case and some of its implications for EIA. So thank you very much for that. And as Kate said, please do put your questions in the Q&A box. We already have some in there, so I'm going to kick straight off with some of those. So one of the first questions here is about thinking about the international landscape. And of course, OEP only has jurisdiction over England. But I wondered if you could reflect a little bit about whether there is similar cases being done internationally, or whether you think this case will have any international implications.
Yeah, so we had a look when we were preparing our intervention. We had a look at what was going on in the rest of the world, and there were a couple of examples at that time where similar decisions had been made, where so I think in Norway and Australia, there have been decisions where these kind of emissions should be taken into account in their equivalent of EIA. But then also there were other decisions. So in Ireland, there was a case about a new cheese factory that was about upstream effects, but essentially looking at whether the emissions from the additional cows that would be needed to make the cheese should be taken into account. And there, the Irish Supreme Court found that no, that was too remote. And the UK Supreme Court kind of disagreed with that in the Finch case. So I think kind of, as far as I'm aware, like directly on this point, this is probably one of the first. And I do think it will have some implications internationally. And I imagine, just given where we are with the climate crisis and also the development of climate litigation around the world, I would expect that this case will be cited in a lot of other cases internationally. But I think it's probably, and I can't claim to have read in huge detail the Norwegian case, so that may be exactly on the point as well. But I think this is probably the clearest finding that these are things that should be assessed as part of EIA. Obviously, it would depend what the specific international legislation is, but certainly in Europe, you would expect it to be quite persuasive, because at least at the moment, the legislation is pretty much the same, comes from the same directive.
Great, thank you. And I wonder if it could also have any negative impacts, in that maybe oil and gas developers will look to develop outside of the UK. Has that been thought of at all in terms of some of this work?
Yeah, I mean, it's not something I'm aware, like personally, it's not something the OEP has looked at, but I can certainly see that is a risk. And I think that is something that we need to think about more broadly in all of the work that we're doing in trying to improve the environment in the UK, is the risk of effectively just offshoring the problem and encouraging businesses to go in places where perhaps regulation is not so tight. So I'm sure that is something that is a risk. Yeah, and we'll need to see how that pans out.
Great, thank you. And there were kind of two main things you mentioned when the Supreme Court were making their judgment. It was about kind of certainty of what would happen, and being able to also calculate what those emissions might be. There's just one comment here that's saying, how would an EIA for this type of project have a consideration of any mitigations that might be applied when actually burning oil? And did that come up in any of the discussions? So the actual emissions would be difficult to calculate.
Yeah, I think that the general view, certainly I can say it was the view of Horse Hill's lawyers at the hearing, was that there were really no mitigations, which was part of their reasoning for saying, well, how it shouldn't be assessed as an effect, because there's nothing you can do about the effect. It's just it will happen. So from that perspective, that's why I sort of think that there is a slight sort of, there are train tracks for the Finch decision, because it is clear that I think you need to have to determine whether a potential effect is likely or even inevitable. You do need to have an evidence base on which to make that determination. And so if the evidence is so lacking that you would just be speculating about whether it would happen or how much it would happen, then I think the court is clear there that that wouldn't be required to be assessed. So there does need to be some ability to actually assess it. But the only kind of thing that came up in the case specifically around mitigation was this idea that appeared to be agreed by everybody, that they actually couldn't really be mitigated and that they would happen. And that was part of but the court said, well, that doesn't matter, they should still be assessed.
Great, thank you. And then there's a question here that's kind of thinking about the implications of this beyond the question of downstream emissions, which is, do you think there could be a change in the consideration of indirect effects of supporting infrastructure projects, which are required as a result of a larger project, because often supporting infrastructure isn't considered in the main project EIA?
I think that's an interesting question, because I think that is probably something that is being thought about quite a lot within the relevant industries, because how you effectively, how does this apply to upstream emissions is something that hasn't really been considered. And I guess all I can say really, which is probably not that helpful, is just to consider, is it, are they inevitable? Are they, what kind of level of impact are they going to have? And I suppose, the safest option for developers, which, I think I could see may cause concern about increased costs and certainly increased time, would be, if it is possible to assess it, then assess it. I think that's probably the kind of the safest space, but I do think there is definitely room in that kind of question around whether something is likely or significant. That's still genuinely a matter of judgment that will have to be considered on a case-by-case basis. So I don't think there's kind of a generic rule you can take from it outside of these downstream emissions, but certainly you can see that there will be, there are certainly links to those upstream emissions, what's being inputted for that project. So yeah, I think it could have an impact.
Thank you. And there's another question here that also said, super helpful. Thank you so much for that presentation. But they're wondering, do you think there's going to be any differences in potential judicial reviews or EIA procedures more generally for offshore fossil fuel developments versus onshore developments? Mostly thinking about the differences and who makes the ultimate decision there. So it's often not local planning authorities for offshore development.
Yeah, I mean, that will be interesting to see as well. I mean, you can already see in the Jackdaw and Rosebank cases, the decision maker there is the North Sea Transition Authority, and they are the ones who have said they're not going to defend the challenge. I suspect you might expect that they would have a more they might have availability of more expertise, and perhaps they'll be feeding more tightly into the guidance, because that's the main thing that they're doing. Whereas obviously local planning authorities have got to make planning decisions on everything. So I think that makes it more difficult. I don't know that I think probably what will guide that is how useful this new guidance ends up being, because if that guidance can be, I think it's intended to be applied to both the North Sea Transition Authority, other kind of central government departments, perhaps if there were development consent order level infrastructure that was being proposed, that was made more centrally. I think it is intended to apply to both those central decision makers and the local planning authorities. But I think that will be a test of that guidance actually, as to whether it is useful and easily followed by both decision makers, both types of decision maker.
That makes sense. Thanks. And we've got a comment here from someone that's saying effects are a matter of law. Whether they are likely or significant is a matter of judgment. Do you think that this is going to open the floodgates for judicial reviews in these areas?
I know that is certainly something that a lot of commentators sort of raised in the immediate aftermath of the case. I actually don't think it will, because there's quite a lot of case law already about a kind of effects and how far removed they are from the project, which were all referred to in Finch. So I think I do think my personal view is that actually, where an effect is not inevitable, there will still remain a lot left for evaluative judgment of the planning authority. Will it mean that more judicial review claims are brought? Potentially, particularly in relation to kind of controversial infrastructure projects. But again, this is personal view and entirely based on just a crystal ball, I don't think it will lead to that many more successful judicial review claims.
Great, thank you very much. And a question here is, do you think that this type of ruling will only apply to impacts that don't have a defined geographic location? For example, things like greenhouse gas emissions, as location of downstream effects is likely to be less certain?
I think that certainly impacted the decision. I mean, in some ways you can see where if the location of the effect was known, that might be a stronger reason for it to be assessed. But here they were just clear that the fact that that location wasn't known was not a reason for it to not be in effect. So I think the particular reasoning here, yes, applies to something, an impact that was not, we didn't know where we don't know where it will be felt geographically. But I think if you're in a situation where you did know where the effect was and all of the other tests were met, then it would still follow that should be assessed.
Great, thank you so much. And thank you for answering so many questions there. I'm sorry we have not had a chance to get through all of them today. There's still quite a lot there. So I'm sorry to everyone whose questions I didn't get to. Just one final one to finish with, if this is okay, which was, how was this Finch case actually drawn to your attention? How does the OEP get involved?
Yeah, so I mean, it is a good question, and I should say kind of on our website, and hopefully towards the end of November and December, we're going to publish some guidance on how we make our decisions on what cases we intervene in, and part of that will be kind of how we do the intelligence gathering. In this case, we as the legal team here, we review environmental judicial review cases. And so it was the Court of Appeal judgment we saw, and then I think we just saw a press release that said that Mrs. Finch was applying for permission to apply to Supreme Court. And then we did have direct contact with the barristers on who were working on the case. And so that's another way that we think that we will continue to kind of building up those networks. And I think it's a good opportunity here to say, we are we try to keep up with what's going on in the kind of public sphere and follow judgments. We might miss things. We also obviously don't know about cases that are kind of being considered and being thought of before they're brought, and we're always very open to receiving information from claimants or defendants or their lawyers, because I think that's something we're trying to develop is our intelligence gathering. How do we find out about these cases? But in this case, because it was at the Supreme Court level, we were aware of the Court of Appeal decision, and we already kind of were thinking about it in the context of our work that we were doing at the time. So yeah.
Great. Oh, well, thank you so much, Kate, for presenting today. That was really interesting and really useful to hear your thoughts on all of those questions as well. So a massive thank you to you. And a thank you to all our attendees as well. I hope you all found that as interesting as I did. If you are watching the recording on YouTube, please subscribe to our channel, like the video, and hit the bell to gain notifications of new content. Thanks so much for joining. Thanks, Kate. Have a great rest of your day.